This is a screenshot of a comment that was left on my last video, and I'm not going to read through the whole thing because you can pause this video and you can read it all if you want to. But what I want to do is I want to talk specifically about the part that mentions Pitocin and how that can tie into legal causation when we're talking about HIE cases. HIE is short for hypoxic ischemic encephalopathy. Before we go further, I want to make sure that I clarify something with all of this. I'm talking here about causation as it generally relates to negligence and how negligence is viewed in the United States. Other countries can have different standards and different approaches to negligence, and I'm going to say that you need to always check your jurisdiction and the laws for your jurisdiction about the specifics on how your area deals with negligence and specifically causation. I mention this because I've had questions from viewers outside of the United States and in other places where the rules can vary widely with this. So there are a lot of strong opinions when it comes to Pitocin, especially here on social media. Some mothers will say that the drug is dangerous and that it should never be used. You've got other mothers that share that they were given Pitocin and that they've had no problems at all during their labor and delivery. My position with all of this is that I'm not here to tell a mother that whether they should or they should not use Pitocin. That's not my role as a birth injury lawyer. That decision to use Pitocin, that is a medical one, and it should be made between a mother and her healthcare providers with all of this. So that's my position on it. Now, let's talk about causation, because this is where the legal side can look very different from some of the medical discussions and maybe some of the other discussions that you see online with all of this. You've got some research that will say that Pitocin can increase the risk of HIE, but in a legal case, it's not enough to say Pitocin was used and my baby was injured. To prove causation in court, we have to connect the dots on the chain of events that occurred, and that chain is going to look something like this. Think about it this way. Pitocin leads to very strong or very frequent contractions. That's what it can do. That overstimulation is then called tachycecily. When you have tachycecily, when that happens, the baby may not get enough oxygen between the contractions. If that continues, the fetal heart monitor will usually show warning signs on the baby's side. You can see late decelerations, you can see minimal variability, you might see prolonged bradycardia, you may see absent variability. You may see those things on the monitor. At that point, the responsibility is going to now shift to the medical team with all of it. They must recognize these signs and they have to respond. So what that means is they may have to stop giving Pitocin. They may have to give fluids or oxygen. They may have to reposition mom, or if things are not improving, they may have to move to an emergency C-section. And that's where all of this can become so important with what we're talking about today. If that distress is recognized quickly and the baby recovers, then the chain of causation is broken and a permanent injury is generally not going to occur. But if that distress, if it continues on for too long without correction, oxygen deprivation can begin to progress into HIE. That prolonged exposure is what often turns a risk factor into a potentially preventable brain injury. So from a medical legal standpoint, the real issue here is not going to be, was Pitocin given? That's not the crux of the issue. It's whether the Pitocin set off a chain of events that were ignored or mismanaged, leading to prolonged fetal distress and then injury to the baby. That's one way causation analysis can be set up in a courtroom, though, other lawyers may present it a little bit different with everything, but that's the gist of where we're going. It's also important to note that these cases, that when we're talking about these cases, we have to have skilled medical experts for them. Multiple experts are usually going to be needed to provide opinions on things like the standard of care, on things like causation, and on damages. And without the right expert guidance, proving causation with all of this, it can become even much harder. Now, with all of this, what I'm talking about, let's play devil's advocate with everything, because this is exactly the type of argument that hospitals and defense lawyers, when the facts are relevant, they can make these arguments. We know that mismanaged Pitocin can cause HIE. But let's imagine you've got a baby who is small for gestational age, for term gestational age, with a small head circumference at term, a placenta that's showing signs of growth restriction or other oxygen-related issues during pregnancy. Even if the Pitocin was mismanaged during labor, the hospital could argue that the injury actually started before the mother was admitted. And if the OBGYN managing the pregnancy isn't directly connected to the hospital, the defense will argue that their medical staff didn't cause the underlying brain injury. This can be a very common defense in these cases, and it highlights why legal causation is so complicated. There are a lot of nuances when it comes to these things, and each case is going to be unique when we're analyzing it. And this is why a thorough birth injury investigation is so critical with all of this. Plaintiffs' lawyers handling these types of cases, like me, we have to be able to anticipate as many of these potential defenses and these issues as possible on the front end. You have to make sure that the hatches are bolted down before you're pressing forward with these types of cases. And the reason is simple. You don't want to get in the middle of your litigation and discover all of a sudden you've got major weaknesses in your case. Skilled defense lawyers, they're going to spot these gaps. They're going to file certain types of motions. For example, motions for summary judgments or other types of motions to dismiss your case if it's not set up correctly. And because of all of this, you've got to have patience. It takes time to gather all of the medical records, to conduct the proper analysis, which is like what we're talking about today, securing the right experts and to be able to get the opinions that you need. If you don't have the patience to set this process up, this may not be the right path for your family. And that's okay. That is okay with all of this. Understanding this up front can help set realistic expectations for you and avoid rushing into a process that is extremely detail-oriented and extremely technical. Again, I'm Marcus Boston. If you have any other questions about your baby's HIE brain injury at birth or a subsequent CP diagnosis, if you've got these types of questions about your baby at birth from a medical legal standpoint, don't hesitate to reach out and contact me. You can find out more information about me in my profile. If you are on certain apps, you can send me a DM and we could chat a little bit about your baby story, or you can just wait and watch the picture that follows the end of this video. All right, that's going to be it for this afternoon's educational video. I know this was a little bit longer educational video, but I wanted to go in as much depth of this as reasonable for this video to try to help you all be able to understand these critical issues. If you do know a family that is going through something like this, or they have these types of questions, go ahead and take a few moments and share this with them. That way they can understand these types of issues and they can understand this so they can make the best decisions for themselves and for their family. All right, that's going to be it, guys. Take care. Enjoy the rest of your day.